Welcome, everybody. This is Cameron. This is Power in Here and the People, and I wanted to read this very important document today. This is going to be about qualified immunity. This is Desmond Green versus Detective Jacqueline Thomas. Order denying qualified immunity. Before Carlton W. Reeves, District Judge. For nearly 2 years, the state of Mississippi falsely accused Desmond Green of capital murder. A detective used a lying drug-impaired jailhouse informant to lock Green up. The detective also steered the informant to select Green's face from a photo lineup. It was a horrifying wrong. Compounding Green's suffering was another horror. The jail he was held in was full of violence, rodents, and moldy food. He says there was constant yelling, fighting, and threats, unquote. Green, quote, often did not have a mattress or even had a pad to sleep on, and he slept on the floor, unquote. He, quote, constantly feared for his life, unquote. The informant eventually recanted. The state then dropped the charges, but the ordeal cost Green almost 2 years of his life. Green filed this lawsuit to seek justice for those two wrongs: his prosecution and conditions of confinement. He has sued the detective who locked him up, her employer, the city of Jackson, Mississippi, and the operator of the Hinds County Detention Center, Hinds County, Mississippi. Green is now on the precipice of being wronged a third time, not by a rogue officer or jailer, but by the law itself, because the detective says the legal doctrine of qualified immunity requires the court to dismiss Green's claims against her. Qualified immunity was invented by the Supreme Court in 1967. Qualified immunity was invented by the Supreme Court in 1967. In plain English, it means persons wronged by government agents cannot sue those agents unless the Supreme Court previously found substantially the same acts to be unconstitutional. See Mullenix versus Luna, 2015. A cynic might say that with qualified immunity, government agents are at liberty to violate your constitutional rights as long as they do so in a novel way. And I want y'all to know that if you look at the top of this page real quick, this was filed March 20th or May 20th of this year, y'all. This is important, very important. Most plaintiffs in this situation argue that the officer that wronged them isn't entitled to qualified immunity. Green does that. Unlike others, though, he has taken the next step and argued that qualified immunity is itself unlawful. He joins lawyers, professors, judges, and even Supreme Court justices who have called for the doctrine's re-evaluation, if not its abolition. The court agrees with these calls for change. The court agrees with these calls for change. The court agrees with these calls for change. Congress's intent to protect citizens from government abuse cannot be overridden by judges who think they know better. As a doctrine that defies this basic principle, qualified immunity is an unconstitutional error. Qualified immunity is an unconstitutional error. It is past time for the judiciary to correct this mistake. The court presents Green's allegations, the governing legal standards, and the substantive case law below. It concludes that the detective is not entitled to qualified immunity. Her actions violated clearly established law. Even if this were not the case, the detective's quest would fail, for qualified immunity has no basis in law. It is an extra constitutional affront to other cherished values of our democracy. The detective's motion to dismiss is therefore denied. 1. Factual and procedural history. The following allegations are drawn from Green's complaints, its attachments, and the documents it references. Brad, Coupon Network, LLC versus Catalina Marketing Corp. At this stage of litigation, his allegations must be taken as true. On February 13, 2020, someone shot Nicholas Robertson in Jackson, Mississippi. A wounded Robertson knocked on the door of Avery Forbes. The police report says Robertson was conscious and spoke to Forbes. By the time the police arrived, however, Robertson was unresponsive. He died in Forbes' home. 2 months later, law enforcement arrested Samuel Jennings for burglary and grand larceny. He was jailed at the Hinds County Detention Center. While there, Jennings provided a statement about the Robertson murder to Jackson Police Department. JPD Detective Jacqueline Thomas. Jennings handwrote his statement on JPD form. It read, "I had gotten out of the hospital and was laying in the bed back in the shed. Desmond Green, undecipherable, had walked in, not know I was in there, and started apologizing for what had happened to Tuan about him shooting Nick Robertson. Said him and Chris Martin and Brandon Simrall had took body from Teresa to Flower and dropped off the body. Desmond and Green told me about loud he shot Nick Robertson. Bubba." Samuel Jennings, 4/10/20. Jennings and Detective Thomas signed the statement. The accusation came as a surprise to Green. He says he didn't know Robertson, much less shot him and move his body. With this uncorroborated statement, however, in July 2020, Detective Thomas and local prosecutors got a grand jury to indict Green for capital murder. 3 footnote. Because grand jury proceedings are secret, allegations about what was presented or omitted in the grand jury room will in some sense be speculative. Wilson versus Strawman. This reality is discussed in detail below. Green was arrested and detained in the Hinds County Detention Center. He remained there awaiting trial in an inhumane way, or a facility he claims was infested with rodents and snakes, and his cellmate was stabbed, where his food was moldy and stale, where he often had to sleep on the cell floor, and where he lived amidst constant violence, yelling, fighting, and fear. More than a year passed. Jennings finally recanted in March 2022. He told public defenders and their investigator that he was drug impaired when he accused Green of murder. He admitted that his statement was baseless, blamed his lie on meth abuse, and said he didn't know who killed Robertson. A written statement memorialized Jennings' recantation. In it, Jennings swore under oath that he never heard Desmond confess to murder. "I was just high and tried to help myself get out of jail," he wrote. Jennings added, "I had originally picked photo 1 top left corner, but the detective pointed to the 5th photo of lineup, which is bottom row, middle photo, but I didn't know anything about this charge." Jennings repeated this to members of the Hinds County District Attorney Office the next month. He said he had taken 1.5 shots or 80 to 90 units of meth shortly before he gave Detective Thomas the April 2020 statement. He knew nothing about Robertson's murder and did not remember what he told the detectives. Footnote 4. Jennings' drug habits are unknown, but his statement is consistent with using 50 milliliter syringe to inject meth 1.5 times. The record does not yet show what effect intravenous delivery of that amount of meth would have on a person, whether it resulted in visible marks on Jennings' body that Detective Thomas would have seen, or whether the detective otherwise knew or reasonably should have known of Jennings' drug use. Jennings added that he was in the hospital the day of the murder and suffers from a variety of mental health disorders. On April 14, 2022, the prosecutor moved to remand Green's case. The state was unable to meet its burden of proof. The prosecutor attached Jennings' written recantation. The presiding judge granted the motion and dismissed the case. On April 21, 2022, Green was released from jail. He had been incarcerated in Hinds County Detention Center for 22 months. This lawsuit followed in February 2023. In it, Green claims that Detective Thomas violated his rights under the Fourth Amendment, the 14th Amendment, and Mississippi law to be free from malicious prosecution and malicious arrest without probable cause. Footnote 5, 6, 7, and 8. Again, we do not know whether Detective Thomas knew or reasonably should have known that Jennings suffered from mental health disorders, the issue will be explored during discovery. That is a formal way of saying the prosecution wanted to abandon the case. The motion to remand suggests that Jennings may have given statements to law enforcement in February and April 2020. See docket number 1-1. Green's pleading, however, refers to only one statement, the one Jennings made on April 10, 2020. The court does not know the truth of the matter, but for present purposes must adopt Green's versions of events. Green's complaint says he was incarcerated for 2 years and 3 months, but in July 2020 to April 2022 was under 2 years. The parties may clarify the exact timeline in discovery. Green says the detective withheld crucial evidence from the grand jury, including the police report stating that Robertson was conscious when he arrived at the Forbes residence, information that the informant was unreliable as an addict and criminal, and other police evidence indicating that Robertson had been with a man named Brandon Summerall rather than Green shortly before the shooting. Green attached to his complaint in the informant's sworn statement about Detective Thomas's manipulating the photo lineup. As for the detective's employer, Green says the city of Jackson is liable for an unconstitutional custom or practice of failing to train its officers on probable cause and had to corroborate informants' statements. He says that custom or policy caused his injuries. Green then claims Hinds County is liable for subjecting him to unconstitutional conditions of confinement. He observes that during his detention, the Hinds County Detention Center was under a federal consent decree that sought to address persistent understaffing and conditions deficiencies. United States versus Hinds County. All of Green's constitutional claims are brought by way of 42 U.S.C. Section 1983. In Mississippi, the tort of malicious arrest is now called false arrest. City of Mound Bayou versus Johnson. Green later withdrew this state law claim. Now before the court is Detective Thomas's motion to dismiss pursuant to Federal Rule of Civil Procedure 12b-6. That number again, bro. It is always prevalent for me. 3-6. She says qualified immunity protects her from this suit. Legal standard. To survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. Ashcroft versus Iqbal, 2009. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw reasonable inference that the defendant is liable for the misconduct alleged. On Rule 12b-6 motion, a district court generally must limit itself to the contents of the pleadings, including attachments thereto. Brand Coupon Network. The court may also consider documents attached to either a motion to dismiss or a opposition to that motion when the documents are referred to in the pleadings and are central to a plaintiff's claims. Ultimately, the court's task is to determine whether the plaintiff has stated a legally cognizable claim, not to evaluate the plaintiff's likelihood of success. Thus, the court must accept all well-pleaded factual allegations as true and draw reasonable inferences in favor of the plaintiff. The same pleading standard applies to motion to dismiss based on qualified immunity. 3. The Ku Klux Klan Act and qualified immunity. The origins of the statute. After the Civil War, white supremacists unleashed waves of terrorism across the South. See Eric Foner, Reconstruction, America's Unfinished Revolution, 1863 through 1877, 1988, Nicholas Lehman, Redemption, The Last Battle of the Civil War, 2006, Lawlessness Was the Order of the Day, Pearson versus Ray, 386, U.S., 1967, Douglas J. Dissenting. Groups like the Ku Klux Klan carried out thousands of beatings, lynchings, and incidents of torture and mutilation. Robin D. Barnes, Blue by Day and White by Night, regulating the political affiliations of law enforcement and military personnel. 81 Iowa L. Revised 1079, 1099, 1996. These atrocities were inflicted with impunity because judges, politicians, and law enforcement officers were fellow Klansmen and loyal sympathizers. White supremacy empowered them to kill black men, women, and children without fear of consequences. See Tiffany Wright et al., Truth and Reconciliation. The Ku Klux Klan hearings of 1871 and the genesis of Section 1983, 126 Dickinson, L. Reverend 685, 690-9-92, 702, 2022. Congress responded with the Ku Klux Klan Act of 1871. See Monroe v. Pape, 365 U.S. 167, 172 in 1961. It wanted to provide a remedy for the wrongs being perpetuated on black folk. Pearson 386 U.S. at 559 Douglas J. dissenting. The Ku Klux Klan Act imposes liability upon any person who, acting under color of law, deprives another of a federal right. See 42 U.S. Section 1983. In other words, the statute guarantees basic federal rights of individuals against incursions by state power. Patsy versus BD of Regents of State of Florida, or FLA. 457 U.S. 496 503 1982. Because the law is codified at 42 U.S.C. Section 1983, and because lawyers usually shy away from saying Ku Klux Klan, this law is often referred to as Section 1983. This court will refer to the law by its formal name as a reminder of why the Reconstruction Congress saw the need to enact it. Man, thank you, brother. Our world is waking up, y'all. I really thank the great creator. I really do, man. A person seeking damage for a constitutional violation does not have to cite or quote the Ku Klux Klan Act to get in the courthouse door. Johnson versus City of Shelby, Mississippi, 574 U.S. 1011 2014. Federal procedure is not that stingy. Whenever a person brings a constitutional claim through, they invoke the Ku Klux Klan Act's authority. The statute is how Congress chose to provide a remedy to be broadly construed against all forms of official violation of federally protected rights. Moneo versus Department of Society Serves of City of New York, 436 U.S. 658 1978. The very purpose of Section 1983 was to interpose the federal courts between the state and the people as guardians of the people's federal rights, to protect the people from unconstitutional action under color of state law, whether that action be executive, legislative, or judicial. Mitchum versus Foster, 407 U.S. 225 242 1972. The Ku Klux Klan Act established a new legal order that contemplated direct federal intervention in what had been considered to be state affairs, a system in which federal courts were to enforce newly created federal constitutional rights against state officials through civil remedies and criminal sanctions. Catherine A. McFarland Lane, Accelerated Civil Rights Settlements in the Shadow of Section 1983, 2018, Utah, L. Rev. 639, 660, 2018. B. The Invention of Qualified Immunity. The Ku Klux Klan Act created a species of tort liability that on its face admits of no immunities. Wyatt v. Cole, 504 U.S. 158, 163, 1992. Quotation marks and citations omitted. It had no exceptions for government officers who violated federal law in purported good faith. Patrick Giacomo and Anya Bidwell, Recalibrating Qualified Immunity, How Tenzin versus Tanvir, Taylor versus Riojas, and McCoy versus Alamu, signal the Supreme Court's discomfort with the doctrine of qualified immunity. 112J Criminal L and Criminology 105 119 2022, rather, the historical rule of strict liability continued. The Supreme Court explained why in 1882. No man in this country is so high that he is above the law. No officer of the law may set that law a defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law and are bound to obey it. It is only supreme power in our system of government, and every man who by accepting office participates in its functions is only the more strongly bound to submit to that supremacy, and to observe the limitations which it imposes upon the exercise of the authority which it gives. United States versus Lee, 106 U.S. 196, 220, 1882. In the decades to follow, the Supreme Court did not recognize good faith immunity as a defense to suit. See Baxter versus Bracey, 140 S.C.T. 1862, 1863. 2020, Thomas J. dissenting from the denial of certiorari. That all changed in Pearson versus Ray, a case arising out of Jim Crow, Mississippi. In Pearson, police officers in Jackson arrested and jailed peaceful ministers who entered a white-only waiting room in a bus terminal, 386 U.S. at 552 through 53. The ministers eventually beat the bogus criminal charges in Mississippi State Court, then sued the police officers in federal court for violating their constitutional rights as guaranteed by the KKK Act. On appeal, the Supreme Court decided that the police officers could assert a form of immunity, a qualified immunity, by claiming that they acted in good faith when they had arrested the ministers to prevent violence. The justices derived this immunity from good faith and probable cause, defenses available to officers facing common law claims. This was a strange conclusion, historically speaking. Again, lawsuits against officials for constitutional violations did not generally permit a good faith defense during the early years of the Republic or in the decades after the Ku Klux Klan Act. William Baudet. Is qualified immunity unlawful? 106 California L. Rev. 45, 55, 57, 2018. In addition to the limited extent a good faith defense did exist in some common law suits, it was part of the elements of a common law tort, not a general immunity. Yet the court either ignored or misstated this history. Dobbs versus Jackson Women's Health Organization in 2022. Pearson was strange factually too. The officers had no proof that the ministers were a threat to public safety. The true threat came from the menacing crowd of 25 to 30 bystanders in a very dissatisfied and ugly mood, mumbling and making unspecified threatening gestures and threatening violence. Pearson, 386 U.S. at 553. The officers never even claimed a good faith belief that the ministers had violated the law. It was as if the officers had arrived at a hostage situation, protected the kidnappers, and arrested the hostages. And Pearson was strange legally, if you step back and consider it from a distance. The justices took a law meant to protect free people exercising their federal rights in southern states after the Civil War, then flipped its meaning. In creating qualified immunity, the higher court protected the southern officials violating those federal rights 100 years after the war ended. Southern trees bear strange fruit, indeed. This even happens today. In one recent case, police officers in Texas arrived at the scene of a car crash, let the drunk driver go, arrested the Good Samaritan who called 911 and charged the Good Samaritan with a felony. Hughes versus Garcia in the F. 4th, number 22-20621, 2024, WL 1952868 at 1, 5th Circuit, May 3rd, 2024. The Fifth Circuit was horrified. It thought it was insane and irrational that the police officers sought qualified immunity for such obviously unlawful conduct and expressed astonishment that their lawyers defended them. But it is not clear that the Texas officers did anything that different from the Mississippi officers who arrested and jailed the ministers in Pearson versus Ray. It is difficult to see qualified immunity's creation as anything other than a backlash to the civil rights movement. Yet even as America has incorporated the lessons of that movement into its dominant narrative, that of American progress, the law has retained this vestige. Since the 1960s, in fact, the Supreme Court has continued to shape, enforce, and expand qualified immunity, making it almost impossible to overcome. See modern qualified immunity. Today, the doctrine of qualified immunity protects public officials from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. Ramirez versus Martinez. It is supposed to be balance. Two important interests: the need to hold public officials accountable when they exercise power irresponsibly, and the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. Pearson versus Callahan, 2009. When a defendant asserts qualified immunity, the burden shifts to the plaintiff, who must overcome the defense. See Newman versus Goodry. Fifth Circuit, 2012. To do so at the motion to dismiss stage, the plaintiff must allege that the defendant violated the plaintiff's constitutional rights and the defendant's actions were objectively unreasonable in light of clearly established law at the time of the violation. Cowart versus Irwin, 2016 in the Fifth Circuit. A clearly established right is one that's sufficiently clear that every reasonable official would have understood that what he is doing violates that right. We do not require a case directly on point, but existing precedent must have placed the statutory or constitutional question beyond debate. Put simply, qualified immunity protects all but the plainly incompetent of those who knowingly violate the law. Mullen X, 577 U.S. at 1112. The clearly established requirement is unusual in the law. Other torts don't require it. If a surgeon accidentally leaves a sponge in your abdomen before stitching you up, you do not have to point to an existing appellate decision, clearly establishing his error before proceeding with your claim. You simply state the facts and explain that the surgeon's conduct fell below the standard of care. The clearly established requirement is nevertheless the governing standard in constitutional torts. Under this standard, bullet point, courts let correctional officers hold a person for 6 days in a frigid cell, covered in other person's feces and forced to sleep naked in sewage, because it was only clearly established that prisoners couldn't be housed in cells teeming with human waste for months on end. Taylor versus Stevens, Fifth Circuit, 2019. Bullet point, courts let police officers steal $225,000 in cash and rare coins. Jessup versus City of Fresno, Ninth Circuit, 2019. Although that was morally wrong, the officers did not have clear notice that it violated the Fourth Amendment. Bullet point, courts let correctional officers spray some chemical agent in a person's face for no reason at all, because it was only clearly established that guards could not use the full can of spray. McCoy versus Alamu, Fifth Circuit, 2020. Bullet point, courts let police officers who were inside a car kill a person who didn't warrant lethal force. The law clearly established only that an officer could not shoot a person from outside a car. Stewart versus City of Euclid, Ohio, Sixth Circuit, 2020. Footnote, after media scrutiny, the Supreme Court reversed Taylor versus Riojas, 2020. The justices thought no reasonable correctional officer could have concluded that under the extreme circumstances of this case that it was constitutionally permissible to house Taylor in such deplorably unsanitary conditions for such an extended period of time. The fact remains that the first 4 federal judges to hear Mr. Taylor's case all concluded that the correctional officers were entitled to qualified immunity. Equally sad is that the lower courts denied Mr. Taylor's plea to have a lawyer appointed to help him. The Court of Appeals found that Mr. Taylor's case did not present exceptional circumstances requiring appointment of counsel. Taylor versus Stevens, Fifth Circuit, 2017. Bullet point, A court let 5 police officers shoot a man 22 times as he lay motionless on the ground after tasing him 4 times, kicking him, and placing him in a chokehold. Estate of Jones versus City of Martinsburg. Fourth Circuit of 2020. It was not clearly established that the officers could not shoot a motionless person who possessed a knife. Estate of Jones versus Martinsburg. September 7, 2018. Courts let a correctional officer watch a suicidal detainee strangle himself to death with a telephone cord after officials placed him in the cell with the cord, knowing he was unstable and had repeatedly attempted suicide. Cope versus Cogdeo. Fifth Circuit, 2021. It was not clearly established that the correctional officers who watch a person attempt a suicide had to call for emergency medical assistance. And a court let a deputy sheriff shoot a 10-year-old child from 18 inches away while the deputy repeatedly tried to shoot a non-threatening family dog. Corbett versus Wickers. No prior decision clearly established that act as unconstitutional. These are just a handful of the cases demonstrating how a lack of precisely analogous controlling law can oftentimes sound the death knell to a Section 1983 claim. Stewart 970 at 681. Donald J. concurring in part and dissenting in part. Such thin distinctions allow officers to evade accountability for excessive abuses, including killing people. Osiachi K. Obasoji and Anna Zaret, plainly incompetent how qualified immunity became an exculpatory doctrine of police excessive force. 2022. And we know which people disproportionately bear the brunt of the doctrine. D. Qualified immunity, racial consequences. Qualified immunity has obvious economic consequences. It discourages victims of misconduct from bringing lawsuits, and those who do not file suits sometimes recover nothing because of it. Qualified immunity accomplishes this by preventing victims of government misconduct from using the discovery tools available to other litigants. See Carswell v. Camp, 2022. Another obvious consequence of qualified immunity, though, is a perpetuation of racial inequality. Research indicates that Black Americans are pulled over more often, searched more often, arrested more often, imprisoned more often, wrongfully convicted more often, and killed by law enforcement more often than other Americans. Bullet point 15. Emma Pearson et al. At-large analysis of racial disparities in police stops across the United States. For Nature, Human Behavior, 2020. Footnote 16. In these jurisdictions, stopped Black and Hispanic drivers were searched about twice as often as stopped white drivers. See also Sherrod Gould and Cheryl Phillips. Police data suggests Black and Hispanic drivers are searched more often than whites. June 2017. Turning to the data, we found that searches of Hispanic drivers yield contraband at lower rates than searches of whites, and that searches of Black drivers yield contraband at similar rates to searches of whites. Footnote 17. Lauren Nickel Gase et al. Understanding Racial and Ethnic Disparities in Arrest, the Role of Individual, Home, School, and Community Characteristics, for 2016. 18. Footnote. William J. Sabo et al. Justice Systems Disparities, Black and White National Imprisonment Trends, 2000 to 2020. Council on Criminal Justice, September 2022. In 2020, Black adults were imprisoned at 4 or 5 times the rate of white adults. Footnote 19. Samuel R. Gross et al. Race and Wrongful Convictions in the United States, 2022. National Registry of Exonerations, September of 2022. Judging from exonerations, innocent Black Americans are 7 times more likely than white Americans to be falsely convicted for serious crimes. Footnote 20. Jeffrey Fagan and Alexis D. Campbell, Race and Reasonableness in Police Killings, 100, BUL, REV 951, 961, 2020. Quote, Black suspects are more than twice as likely to be killed by police than are suspects from other racial or ethnic groups, including shootings where there are no obvious reasonable circumstances. Additionally, It is well established that defendants are more likely to be sentenced to death if their murder victim was white. See Scott Phillips and Justin McCaw, whom the state kills. 2020, McCleskey versus Kemp, 1987. New research indicates that black people on death row even suffer a botched execution more than twice as often as white people. Reprieve, lethal injection in the modern era, cruel, unusual, and racist at 4 April 2020. Qualified immunity then bars many of these individuals from securing justice, shutting the courthouse doors on a large portion of those black and brown civilians who plausibly allege that police officers targeted, surveilled, or stopped them because of their race. Bay v. Falk, 946 F3D 304 331, 6th Circuit 2019. America's long history of racism is unavoidably and inextricably enshrined in the doctrine. Catherine N. Wright and Amanda Geary. Qualified immunity and the color blindness fallacy, why black lives don't matter to the country's highest courts. 2021. With that essential background, the court turns to analyze Green's causes of action. Discussion. Green's claims occasionally share elements or have overlapping analysis. For example, a lack of probable cause supports a Mississippi malicious prosecution claim, a Fourth Amendment malicious prosecution claim, and a Fourth Amendment false arrest claim. The same is sometimes true for Detective Thomas's defense. She has invoked the independent intermediary doctrine as a defense to all of Green's claims. The court will do its best to analyze each claim in defense without unnecessary repetition. State law's malicious prosecution claim. The discussion begins with Green's malicious prosecution claim. Both parties identify essentially the same 6 elements of malicious prosecution under Mississippi law. 1. The institution of a criminal proceeding. 2. By or at the instance of the defendant. 3. Termination of such proceedings in plaintiff's favor. 4. Malice in instituting the proceeding. 5. Want of probable cause for the proceeding. And 6. The defendant's suffering of injury or damage as a result of the prosecution. University of Mississippi Medical Center versus Oliver in 2017. The parties agree that the Detective Thomas caused criminal proceedings against Green, that those proceedings ended in Green's favor, and that Green was injured. They dispute elements 4 and 5, malice and want of probable cause. Each will be considered in turn. 1. Malice. Detective Thomas says Green has not met the high bar required to prove malice. Docket number 10 at 10, quoting Oliver 235. She argues that the malice requires the defendant to have instigated the proceedings for private advantage, such as extortion, debt collection, witness intimidation, and the like. A review of her supporting case does not bear this out. Oliver indicates that while one can certainly prove malice with evidence of such intentions, the list is merely illustrative. It does not establish the threshold for establishing malice. Detective Thomas is on firmer footing when she argues that the malice element requires proof that the defendant instituted the prosecution primarily for the purpose other than that of bringing an offender to justice. Oliver 235. That is the language used in a litany of Mississippi cases. The question then becomes, how does one prove the purpose an officer had in mind when they instituted a prosecution? Malice, after all, is a mental state. Owens v. Kroger Company, 1983. The Mississippi Supreme Court has provided the answer. Quote, the ordinary and popular meaning of malice is usually associated with anger or hatred, ill will, and the like. That court has written, but malice in fact and malice in law are not to be confused. Harville v. Tabor. In legal context, malice does not refer to mean or evil intent. Strong v. Nicholson. Instead, the Mississippi Supreme Court has consistently held that malice can be inferred from the fact that a defendant may have acted in reckless disregard for a plaintiff's rights. Bankston v. Pass Road Tire. See also Nassar v. Concordia, as well as Benjamin v. Hooper. The court tells us that malice may be and usually is shown by circumstantial evidence. Strong, 580. And it has emphasized that since the question of malice is a question of fact, it is to be determined by the jury, unless only one conclusion may reasonably be drawn from the evidence. Benjamin, 568 at 1191. This definition is satisfied here. Green describes several ways in which Detective Thomas acted with reckless disregard for his rights. For one, she pointed out Green to Jennings in a photo lineup after Jennings had identified someone else as the killer. Jennings made a sworn statement attesting to such. See docket number 1-1. Steering an informant to make a false identification could not have been in the interest of bringing criminal offenders to justice. Oliver, 235, 3D at 83. In fact, courts have found identifications unduly suggestive when they steer the witness to one suspect or another, independent of the witness's honest recollection. Unquote. Wilson versus Mitchell in 2001. Green's claim is buttressed by other circumstantial evidence of reckless disregard. He says Detective Thomas ignored and failed to inquire into obvious inconsistencies between Jennings' statements and the police reports she had in hand. See docket number 18 at 6. It would be impossible, he says, to credit Jennings' statement that Green moved the victim's body and honor the police report indicating that the victim was alive when discovered. Detective Thomas then withheld from the grand jury the holes that cast doubt on Jennings' reliability and Green's culpability. These are facts of the case, from which a jury can infer malice. Benjamin, 568 at 1191. The order of events may also indicate malice. If the detective steered Jennings to make a false identification before she presented Jennings' evidence to the grand jury, her acts might be probative of an intent to mislead the grand jurors. Granting reasonable inferences in Green's favor, as the court must at this stage, Detective Thomas acted with reckless and disregard for Green's rights and may be subjected to discovery on the malice element. Green has alleged malice in yet another way, too. In Mississippi, the absence of probable cause for the prosecution is circumstantial evidence of malice. See Brown versus Watkins. As that is a separate element of malice prosecution, however, and mindful of the fact that an absence of probable cause can support multiple aspects of Green's claims, the court now moves on to discuss that issue. Lack of probable cause. Probable cause under Mississippi law requires the initiating law enforcement officer to concurrently have 1. An honest belief on the guilt of a person accused, and 2. Reasonable grounds for such belief. Alpha Gulf Coast Inc. versus Jackson, 2001. Unfounded suspicion and conjecture are not proper bases for finding probable cause. Unfounded suspicion and conjecture are not proper bases for finding probable cause. Benjamin, 568, 1190. Detective Thomas does not identify how Green has failed to sufficiently plead one or both prongs of this standard. Instead, she reiterates the grand jury findings of probable cause, forecloses this claim. See docket number 10, raising the independent intermediary doctrine. The court devotes much time to this objection below. See infra at part 4D. At this juncture, though, the court assesses whether Green has sufficiently alleged a lack of probable cause under Mississippi law. It is difficult to know what to do with the first element, the officer's honest belief in the accused's guilt. Green posits that Detective Thomas could not have believed in his guilt because she steered a pliable informant to Green's face in the photo lineup. See docket number 18 at 9. On the other hand, maybe she steered the informant toward Green precisely because she believed so deeply in Green's guilt. For her own part, Detective Thomas does not advance an argument regarding her honest belief in Green's guilt. Even if we were to credit this element in her favor and assume that Detective Thomas genuinely believed Green was guilty, Green has alleged facts to proceed on the second element, that Detective Thomas's belief was objectively unreasonable. Green's allegations regarding the contradictions between Jennings' statement and the available evidence support an absence of probable cause by demonstrating that a reasonable person would investigate further before instigating a proceeding, unquote, from Benjamin 568 at 1191. A final observation is actually owed here. A significant number of Mississippi cases concerning malice and probable cause are resolved at later stages of litigation. When courts can review the evidence, see at 1192, ordering a new trial after considering evidence of a senseless prosecution initiated in a reckless manner, Royal Oil 500 at 443, affirming jury verdict finding malicious prosecution, Owens 430, 844, reinstating a jury verdict on malicious prosecution, Oliver 235, considering the evidence gathered at summary judgment, Harville 864, vacating defense verdict and remanding for new trial. The weight of the authorities suggests that this court should proceed with caution at a motion to dismiss stage and decline to make determinations that may be better resolved on the evidence. For these reasons, and subject to the independent intermediary defense to be discussed below, Green has sufficiently pled a malicious prosecution claim under Mississippi law. Fourth Amendment claims. The Fourth Amendment to the Constitution is one sentence long. It says, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." U.S. Constitution Amended 4. The amendment is meant to be safeguard the privacy and security of individuals against arbitrary invasions by governmental officials, unquote. Camara versus Municipal Court of City and County of San Francisco, 1967. Green brings two kinds of Fourth Amendment claims. One is for malicious prosecution, and the other is for false arrest. 1. Malicious prosecution. The Supreme Court recently affirmed that persons may bring a standalone Fourth Amendment malicious prosecution claim under the Ku Klux Klan Act. See Thompson v. Clark, 2022. The court cited Winfrey v. Rogers, Fifth Circuit, 2018, as an example of such claim. Given Winfrey, it is clearly established in 2020 that Green had a prior right to be free from initiation of wrongful criminal proceedings without probable cause. Footnote 23. The federal right to be free from malicious prosecution has a peripatetic history in this circuit. See Gordy v. Burns, 2002 Fifth Circuit, describing Fifth Circuit case law on this topic as confused and confusing. The court documents its development briefly. The Fifth Court used to formally recognize a federal malicious prosecution claim as coextensive with the elements of a state law tort of malicious prosecution. In 2003, though, the en banc court overruled this holding, finding that malicious prosecution states no constitutional claim. Castellano versus Fragoso, 2003 Fifth Circuit. Despite this headline, Castellano went on to say that, quote, "The initiation of criminal charges without probable cause may set in force events that run afoul to explicit constitutional protection, the Fourth Amendment, if the accused is seized and arrested, for example," unquote. And later Fifth Circuit cases cited this language to recognize the right to be free from the wrongful initiation of criminal proceedings when they run in conjunction with an unreasonable seizure, sometimes even calling to or analogizing it to malicious prosecution, unquote. See Hernandez versus Terrones, 2010 Fifth Circuit. Good versus Curtis, Fifth Circuit, 2010. Winfrey, 901. Morgan versus Chapman, Fifth Circuit, 2020. Insofar as the defendant's bad actions that happen to correspond to the tort of malicious prosecution result in an unreasonable search or seizure that claims may be asserted under Section 1983 as violations of the Fourth Amendment. Thus, no matter how it is labeled, there is clearly established right in this circuit to be free from wrongful initiation of criminal proceedings that result in a seizure. The Thompson decision clarified two minimum requirements of federal malicious prosecution claims. The first is that the malicious prosecution resulted in a seizure of the plaintiff. 596 U.S. at 43, citation omitted. The second is the favorable termination element of a common law malicious prosecution claim, which has already been addressed above. The Supreme Court did not, however, lay out a comprehensive list of the elements for a Fourth Amendment malicious prosecution claim and largely left the question of elements to the lower courts, unquote. Armstrong versus Ashley, Fifth Circuit, 2023. Picking up on this instruction, the Fifth Circuit subsequently clarified the remaining elements of a federal malicious prosecution claim. It decided to reinstate earlier circuit precedent and require plaintiffs to prove the traditional 6 elements of common law malicious prosecution claim. The bottom line is, in this circuit, a plaintiff pleading a federal malicious prosecution claim under the Ku Klux Klan Act must now allege 7 elements. The 6 traditional malicious prosecution elements used in Mississippi law, and seizure, Thompson, 596 U.S. The parties agree that Green was seized when he was arrested and jailed, docket number 1 at 6, and we need not revisit Green's factual allegations in support of the 6 state law malicious prosecution elements. Based on the resolution of those elements in his favor, and again, subject to the discussion about independent intermediaries, Green has plausibly stated a federal malicious prosecution claim. Footnote: this element does not require the plaintiff to show that the criminal prosecution ended with some affirmative indication of innocence. A plaintiff need only show that the criminal prosecution ended without a conviction. Thompson, 596 U.S. at 49. False arrest and illegal detention. Green alleges several times that Detective Thomas caused his wrongful arrest without probable cause, docket number 1 at 5 through 7. It is not clear whether he intends this as a separate cause of action or if this is an alleged allegation that goes towards his Fourth Amendment claim for malicious prosecution. Out of an abundance of caution, the court turns to this claim now. There can be no doubt that the right to be free from arrest absent probable cause was clearly established at the time of Green's arrest. Alexander v. City, Round Rock, Fifth Circuit, 2017, as well as Maggieri versus Clifton, 1994, Fifth Circuit. The issue is whether Green has sufficiently pleaded facts showing that Detective Thomas violated this right. Quote, to prevail in a Section 1983 claim for false arrest, a plaintiff must show that the officers could not have reasonably believed that they had probable cause to arrest the plaintiff for any crime, unquote. O'Dyer versus Nelson, Fifth Circuit, 2009. Quote, probable cause is established by facts and circumstances within the officer's knowledge that are sufficient to warrant a prudent person, or one of reasonable caution in believing that the suspect has committed, is committing, or is about to commit an offense. Arizmendi versus Gabbard, Fifth Circuit, 2019. As Green points out, the totality of the circumstances test for probable cause requires considering the reliability, credibility, and value of an informant's tip. Docket number 18 at 5 through 6, quoting Illinois versus Gates, 1983. The Supreme Court has consistently recognized the value of corroboration of details of an informant's tip by independent police work and reasonable corroboration by other matters within the officer's knowledge. Indeed, judges in this circuit instruct juries that testimony of an informant seeking money, immunity, or personal advantage must always be examined and weighed by the jury with greater care and caution than the testimony of ordinary witnesses. Fifth Circuit Pattern Jury Instructions Criminal Cases, 1.15, 2019. Jurors are advised that a defendant should never be convicted upon the unsupported testimony of such witness, unless that testimony is believed beyond a reasonable doubt. An eyewitness identification cannot establish probable cause if, quote, there is an apparent reason for the officer to believe that the eyewitness was lying, did not accurately describe what he had seen, or was in some fashion mistaken regarding his recollection, unquote. United States versus Burbridge, Fifth Circuit, 2001. A Fourth Amendment false arrest and illegal detention claim is further buttressed if the officer has conducted a reckless investigation. See Hernandez versus Torrones, Fifth Circuit, 2010. Quote, where a plaintiff makes no allegation that the subject defendant actually arrested or detained him, the defendant will only be liable if his allegedly wrongful action was casually connected to the plaintiff's arrest and detention. Unquote. Mayhew versus Johnson, 2022. This is a common law proximate cause standard. Taking Green's allegations and the available evidence as true, Detective Thomas could not have relied on Jennings' statement or photo lineup identification to reasonably believe that probable cause existed. Jennings' statement is at times incoherent and at other times inconsistent. If Green didn't know that Jennings was in the room, for example, Green could have told Jennings that he shot Robertson. Green further urges the court to reasonably infer that Detective Thomas's personal interactions with Jennings, his admittedly drug-impaired demeanor, and his known criminal history put her on alert about his unreliability. See docket number 18 at 5. Taking the facial incredulity of Jennings' statements together with these circumstances, it would be patently unreasonable for a prudent police officer or an officer of reasonable caution to end the probable cause inquiry there. Yet Detective Thomas did corroborate Jennings' information. When Jennings' statement was finally revealed to be a lie, in fact, presumably the prosecution had nothing else to stand on, thus the district attorney's office dismissed the indictment. Detective Thomas asserts that Green's complaint is too vague. The only allegation about her in the complaint, she claims, is that she obtained a statement from Jennings implicating Plaintiff Green in the murder of Robertson, and therefore the grand jury's indictment protects her. Docket number 10 at 7. Critically, however, Detective Thomas does not contend that Jennings' statement, either alone or in combination, or as the case may be, in contradiction, with any of the other evidence available to the police at time, was enough to establish probable cause. The allegation and available evidence indicate that it was not. The police already had evidence that the deceased body had not been moved, and that Green had not been with the deceased shortly before his death. Docket number 1 at 3 through 4. This contradicted Jennings' statement, meaning it was not reasonably corroborated by other matters within Detective Thomas's knowledge. Jones 362 U.S. at 269. Yet Detective Thomas recklessly ignored the reliability and credibility of Jennings' statement, used it, and withheld contradictory evidence from the grand jury. Green contends, causing his false arrest and illegal detention. She is not eligible for qualified immunity on this claim. Accord Hughes versus Garcia, Fifth Circuit in 2024. 14th Amendment claim. Green's complaint asserts that Detective Thomas violated the 14th Amendment docket number 1 at 7. As before, it is not entirely clear whether he intends this as a standalone cause of action or perhaps a backstop in the event his Fourth Amendment claims fail. In an attempt to unwind the different legal theories at stake, the analysis first addresses whether Green has sufficiently pled a 14th Amendment violation before tackling whether, if so, Green can bring such a claim at this stage. A long line of Fifth Circuit cases clearly establishes a due process right to be free from police misconduct in the form of evidence fabrication, witness interference, or concealment of exculpatory evidence that causes an unlawful arrest, detention, or conviction. For example, a police officer violates the Constitution if procures false identification by unlawful means or deliberately conceals exculpatory evidence. Unquote. Gatier versus Fortenberry. A police officer also violates the Constitution if she knowingly, unlawfully influences witnesses. Good versus Curtis. In keeping with these decisions after surveying its sister circuits, the Fifth Circuit reaffirmed, quote, a due process right 2. Have police deliberately fabricate evidence and use it to frame and bring false charges against a person, unquote. Cole versus Carson in 2015. Hereinafter, Cole vacated sub nom. Hunter versus Cole, an opinion reinstated in part. Given these cases, this court is satisfied that the 14th Amendment right allegedly violated by Detective Thomas was clearly established in 2020. It proceeds to assess whether Green's factual allegations on this claim are sufficient. Again, Green alleges that Detective Thomas secured an unbelievable statement from a high, mentally ill jailhouse informant, did not corroborate the informant's statement, withheld from the grand jury facts about the informant's impairments, criminal history, and incentives, withheld from the grand jury a police report with evidence about the victim's death that contradicted the informant's statement, withheld from the grand jury evidence that another person had been with the victim before his death, and procured a false identification by pointing out Green's photo in the lineup to the informant after the informant initially selected another person's photo. These factual allegations echo those made in cases where a 14th Amendment violation was stated. See Getter 2, 882 F2D at 170, denying summary judgment where officer prodded the witness to select another picture when they had chosen incorrectly, and conceded exculpatory evidence. Good 601 at 398 through 400, denying summary judgment where officer manipulated plaintiff's photo in a lineup to produce a false identification. Burroughs versus City of Laurel, Mississippi in 2019, denying motion to dismiss where all officers allegedly fabricated, misrepresented, and manipulated evidence and reports, including the intentional omission of exculpatory evidence during their investigation and in their pursuit of an arrest warrant and indictment. Given these cases, Green's allegations and attached evidence plead a 14th Amendment due process violation that caused an unlawful arrest and detention. See docket number 1-1. Now, for the wrinkle in Cole 1, the Fifth Circuit seemed to suggest that 14th Amendment claims based on evidence fabrication or withholding exculpatory evidence were limited to circumstances where the Fourth Amendment was unveiling. It is therefore not entirely clear whether Green can maintain a 14th Amendment claim, since he has viable Fourth Amendment avenues of relief. District courts have interpreted Cole 1 in different ways. Some have recognized a 14th Amendment due process claim for pretrial deprivation only when a 14th Amendment claim was unavailable. See McLean versus Davis in 2023. Others have allowed 14th Amendment due process claims to proceed alongside 4th Amendment false arrest or malicious prosecution claims. See Thorpe versus WNS Gaming 2018, or Ducksworth versus City of Laurel 2021, appeal dismissed. Ducksworth versus Landrum in 2023. Certainly, pre-Cole 1 courts allowed the differing constitutional claims to proceed to trial, noting no conflict between them. See Good 601 at 398 through 402. This court could not identify binding authority on how a district court should address these legal theories at the motion to dismiss stage. As Chief Judge Jordan put it in McLean, Cole 1 never says dismissal of the 14th Amendment claim is appropriate if the plaintiff fails to plead facts showing the 4th Amendment claim is unavailing. Instead, the court affirmed dismissal of the 4th Amendment claim because it failed to state a claim, and then allowed the 14th Amendment claim to go forward because the 4th Amendment claim was unavailing. The real question, and one Cole 1 does not address, is when a court must make that call. McLean involved factual circumstances resembling our case. There, the plaintiff alleged that the defendant either intentionally fabricated an autopsy report or recklessly prepared it in a way that caused plaintiff's arrest and detention without probable cause, in violation of the 4th and 14th Amendments. Chief Judge Jordan observed that Federal Rule of Civil Procedure 8 permits plaintiffs to set forth alternative theories of recovery. He further considered Morgan v. Chapman, a Fifth Circuit case which allowed a plaintiff to plead both a 4th Amendment and 14th Amendment claim. 2020. Given these authorities, Chief Judge Jordan let the plaintiff move forward. Finding this reasoning persuasive, the court concludes that Green can pursue alternative theories under the Fourth and 14th Amendments. Independent intermediary doctrine. Detective Thomas avers that the independent intermediary doctrine shelters her from liability on all of Green's claims. The docket at 10 at 6 through 9, relying on Craig v. Dallas Area Rapid Transit Authority, 5th Circuit 2012, and Bueller v. City of Austin, Austin Police Department, 5th Circuit in 2016. She argues that the complaint lacks specific allegations regarding what was improperly presented to or mislead the grand jury. At 6 through 7, Green disagrees and illustrates various ways persons in this circuit overcame the insulation from liability that results when an independent intermediary, such as a grand jury, finds probable cause. Quote, under the independent intermediary doctrine, if facts supporting an arrest are placed before an independent intermediary, such as a magistrate or grand jury, the intermediary's decision breaks the chain of causation for the Fourth Amendment violation. Unquote. Renfrey, 901 F3D at 496. The doctrine does not apply, however, quote, if it can be shown that the deliberations of that intermediary were in some way tainted by the actions of the defendant. Unquote. Cadra versus House Independent School District, 5th Circuit 2010. A law enforcement officer taints grand jury deliberations when she withholds any relevant information. Hand versus Gary, 1988, quote, any misdirection of the magistrate or the grand jury by omission or commission perpetuates the taint of the original official behavior, unquote. Plaintiffs in this situation must specifically allege that the officer deliberately or recklessly provided false information to the grand jury or made knowing and intentional omissions that result in a warrant being issued without probable cause. Anak Wuru versus City of House, 5th Circuit 2021, and Wilson versus Stroman. For example, plaintiffs sufficiently alleged taint when they stated that officers 1. Made material omissions and misrepresentations to the grand jury, and 2. Withheld from the grand jury video evidence that undermined probable cause. 5th Circuit 2022. At the pleading stage, mere allegations of taint may be adequate to survive a motion to dismiss where the complaint alleges other facts supporting the inference. The 5th Circuit has explained its rationale in this way. Given that a general rule of secrecy shrouds the proceedings of grand juries, it is understandably difficult for a plaintiff to know what was said or what wasn't said to the grand jury absent any form of discovery. While that reality does not excuse pleading requirements, it does mean that allegations about what was presented or admitted in the grand jury room will in some sense be speculative, which is why plaintiffs like the ones here will need to allege other facts supporting the inference of what they allege to have occurred in the grand jury room. See also Mayhew. A plaintiff may not, at the initial stage of the litigation, be privy to the facts supporting the taint exception, particularly when it involves secret grand jury proceedings. Green satisfies this standard. Recall that his complaint specifically alleges that Detective Thomas maliciously withheld from the grand jury facts about her jailhouse informant impairments, criminal history, and circumstances. A police report with evidence about the victim's death that contradicted the informant's statement, and evidence that another person had been with the victim before his death, all of which would have undermined probable cause had she provided the grand jury with the full and complete information. Green alleges he would have not been indicted. Green has also more allegations. As already discussed, the informant has sworn under oath that Detective Thomas procured a false identification by pointing to Green's photo in the lineup after the informant had initially selected another person's photo. That evidence indicates that Detective Thomas intentionally and maliciously engaged in obvious misconduct in her pursuit of Green. If the false identification was secured prior to the grand jury's consideration, moreover, Detective Thomas gave the independent intermediary testimony from a man she knew to be untruthful. To this, Detective Thomas advances the Fifth Circuit's decision in Craig and Bueller. Neither case supports her point. In Craig, the plaintiff had been arrested and indicted for tampering with evidence. After being acquitted at trial, she brought false arrest and malicious prosecution claims against the officers, claiming a violation of the Fourth Amendment, the 14th Amendment, and Texas law. Although Craig succeeded in her criminal case, her Ku Klux Klan Act suit failed. The Fifth Circuit assumed that the defendants lacked probable cause to pursue her. Even so, at the summary judgment stage, Craig lacked evidence that they had tainted the grand jury proceedings. Her assertion that a defendant had a personal vendetta against her was nothing more than conjecture. Craig might be more relevant to our case when we reach summary judgment. It does not, however, support the notion that Green has failed to state a claim of a tainted grand jury. Detective Thomas fares no better with Bueller. There, after reviewing the evidence put forth at the summary judgment stage, the trial and appellate courts found no proof that the defendants made knowing misstatements or omissions to the grand jury. The grand jury had in fact heard from Bueller and other witnesses favorable to him and still returned an indictment. As with Craig, Bueller suggests waiting until the evidence is in before adjudicating the issue. This court does not know the truth of Green's claims. All we have are his allegations, one piece of material evidence, and a thin state court record of the criminal proceedings. At this early point in the litigation, though, the legal standard requires this court to take Green's allegations as true and make reasonable factual inferences in his favor. See Iqbal 556 U.S. at 678. Understand that standard. Inconsistent with the substantive law on this subject, Green has sufficiently alleged that Detective Thomas tainted the independent intermediary and caused his wrongful detention. Constitutionality of qualified immunity. If the Fifth Circuit disagrees and grants qualified immunity on any of these claims, Green advances an alternative argument for moving forward against Detective Thomas. He contends that the qualified immunity doctrine is unsound and a misreading of the Civil Rights Act of 1871. This court has written on this topic previously, see Jamison v. McClendon, Mississippi 2020, so it should come as little surprise that the court finds these arguments compelling. Justices, judges, advocates, and scholars have long found fault with qualified immunity, several of the more compelling critiques summarized below. Anderson v. Creighton, criticizing the doctrine as double standard of reasonableness which unjustifiably and unnecessarily upsets the delicate balance between respect for individual privacy and protection of the public servants who enforce our laws. In the context of qualified immunity, we have diverged to a substantial degree from ahistorical standards. Our treatment of qualified immunity under 42 U.S.C. Section 1983 has not purported to be faithful in the common law immunities that existed when 1983 was enacted. Our qualified immunity precedents instead represent precisely the sort of free-willing policy choices that we have previously disclaimed the power to make. In an appropriate case, we should reconsider our qualified immunity jurisprudence. 2018. Lamenting the court's one-sided approach to qualified immunity that tells officers that they can shoot first and think later, and tells the public that palpably unreasonable conduct will go unpunished. See Zadeh v. Robertson. The judge-made immunity regime ought not to be immune from the thoughtful reappraisal. Reich v. City of Elizabethtown, 2019. Opposing holding the Fourth Amendment plaintiffs to an impossibly high standard where they must dredge up a mere image case that happened to arise in this circuit and happened to result in a decision by this court to have any hopes of surviving a qualified immunity challenge at summary judgment. Horvath v. City of Leander, 2020. There is no textualist or originalist basis to support a clearly established requirement in Section 1983 cases, Estate of Jones. Although we recognize that our police officers are often asked to make split-second decisions, we expect them to do so with respect and dignity and worth of black lives. Stewart, 970 at 678. Seemingly endless struggle with applying the doctrine. Cox v. Wilson, 2020. The profound issues with qualified immunity are recurring and worsening. By continuing to await addressing deep and troubling qualified immunity issues brought to our attention time and again, we are complicit. Sampson versus County of Los Angeles, 2020. Hurwitz, concurring in part and dissenting in part. To be sure, the Supreme Court has reiterated that a prior case directly on point is not required, and that officials can still be on notice that their conduct violates established law even in novel factual circumstances. But much like Lucy of Charlie Brown fame, the court repeatedly yanks away the football when the lower courts attempt to apply this language. Jefferson versus Lias in 2021. The paradox that has evolved is that the perceived need to defer to the split-second decisions of trained professionals that is endemic to the jurisprudence in qualified immunity has failed to recognize the collective judgments of those very professionals and their administrative and governing agencies. McKinney of City versus City of Middletown, 2022. The Supreme Court should do away with this ill-founded court-made doctrine. Manzanares versus Roosevelt County Adult Detention in 2018. Factually identical or highly similar factual cases are not, however, the way the real world works. Cases differ. Many cases have so many facts that are unlikely to ever occur again in a significantly similar way. Ventura versus Rutledge, 2019. This judge joins with those who have endorsed a complete re-examination of the doctrine, which, as it is currently applied, mandates illogical, unjust, and puzzling results in many cases. Estate of Smart versus City of Wichita, 2018. The court is troubled by the continued march towards fully insulating police officers from trial and thereby denying any relief to victims of excessive force, in contradiction to the plain language of the Fourth Amendment. Thompson versus Clark, 2018. Case precedent and policy rationale fail to justify expansive regime of immunity that would prevent plaintiff from proving a serious constitutional violation. Honorable Stephen R. Reinhart, The Demise of Habeas Corpus and the Rise of Qualified Immunity, the court's ever-increasing limitations on the development and enforcement of constitutional rights and some particularly unfortunate consequences. 2015. Criticizing a series of decisions not compelled by statute or precedent that has had the harmful practical effect of limiting the ability of all persons to receive the protections of the Constitution, unquote. Honorable John O. Newman. Here's a better way to punish the police. Sue them for money. Washington Post, 2016. Quote, the defense of qualified immunity should be abolished. Honorable Lynn Adelman. The Supreme Court's quiet assault on civil rights dissent, fall of 2017. Quote, the fact is that there is no persuasive legal basis for the doctrine, unquote. Honorable James A. Wynn, Jr. As a judge, I have to follow the Supreme Court. It should fix this mistake. Washington Post, June 12, 2020. Quote, eliminating the defense of qualified immunity would improve our administration of justice and promote the public's confidence and trust in the integrity of the judicial system, unquote. Brief of the cross-ideological groups dedicated to ensuring official accountability, restoring the public's trust in law enforcement, and promoting the rule of law as Amici Curiae, in support of Petitioner Baxter versus Bracey in 2020. Advancing arguments of the American Association for Justice, Americans for Prosperity, Due Process Institute, Law Enforcement Action Partnership, Roderick and Solange MacArthur Justice Center, NAACP Legal Defense and Educational Fund, Incorporated, National Association of Criminal Defense Lawyers, Public Justice, R Street Institute, and Reason Foundation. J. Schweikert, Qualified Immunity, a Legal, Practical, and Moral Pharaoh. Cato Institute, 2020. Ed Yonka et al. Ending qualified immunity once and for all is the next step in holding police accountable. America Civil Liberties Union, 2021. The textual problem. Quote, Congress alone has the institutional competence, democratic legitimacy, and, most importantly, constitutional authority to revise statutes in light of new social problems and preferences, unquote. Wisconsin Center Limited versus United States, 585 U.S. 274 in 2018. In 1871, Congress exercised this authority, confronting the persistent problem of violent white supremacy when it passed into law the Ku Klux Klan Act. Qualified immunity, however, does not appear in the text of the Ku Klux Klan Act. It is not found in any constitutional provision or other statute, nor does it help give life and substance to the specific guarantees in the Bill of Rights, unquote, Griswold versus Connecticut in 1965. The defense has the opposite effect. It nullifies the guarantees of the Bill of Rights. The doctrine's components are similarly untethered to any authority. Justice Thomas has observed several times that the clearly established test cannot be located in Section 1983's text, Hogarth versus Rhodes, 141, South Court 2421 in 2021. Thomas J., respecting the denial of certiorari, an officer's right to immediately appeal the denial of qualified immunity was invented in 1985. See Mitchell versus Forsyth, 1985. And the requirement that existing precedent must have placed the statutory or constitutional question beyond debate, unquote. The Supreme Court came up with that in 2011 in Ashcroft versus Al-Kid in 2011. Not long ago, a plaintiff could satisfy the clearly established requirement by pointing to a consensus of cases of persuasive authority, unquote, Wilson versus Lane in 1999. Al-Kid changed that too. It required plaintiffs to identify a robust consensus of cases clearly establishing the law. 563 U.S. at 742. Today, it is not clear that a robust consensus is enough. The Supreme Court has suggested that only its precedent can establish the law. See District of Columbia versus Westby in 2018. Governments derive their just powers from the consent of the governed. The Declaration of Independence, para 2, U.S. 1776. But the people never enshrined qualified immunity in the Constitution. Our representatives in Congress never put it into the statute or voted on for it. No president signed it into law. If anything, represents a kind of trickle-down democratic legitimacy. Some might say that every legal doctrine has this flaw. It is a fair point, so we should be precise about the critique. Legal doctrines fall upon a spectrum of democratic legitimacy rather than a binary. Some try to implement statutes, even-handedly. See, in regards to Volkswagens of America, Inc., in 2008, in Bank, reconciling the public and private interest factors of forum non-convenience with 28 U.S.C. Section 1404A. Others seek to promote democratic values. Abstention promotes federalism. Prudential standing is meant to enforce Article 3 of the Constitution, and so on. Qualified immunity is different. It adjudicates cases. It ends them, rather than channel them into a better form brought by parties with a more concrete stake in the outcome. It is so removed from the democratic process that it merits the most stringent scrutiny. Legal doctrines have a role in the judiciary, as the Supreme Court has recognized in another doctrinal context, though they should not be imposed at the cost of shrinking the solemn responsibility of the federal courts to guard, enforce, and protect every right granted or secured by the Constitution of the United States, unquote, Cusper versus Pontikes in 1973. It is difficult to see how qualified immunity survives that logic. The countertextual problem. One of Green's more interesting arguments against qualified immunity lies at the intersection of the statute's textual and historical critiques. Green points to a new research suggesting that when Congress enacted the Ku Klux Klan Act, it adopted explicit text that displaced common law defenses, making clear that such a claim would be viable notwithstanding any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary. Alexander A. Reinert, Qualified Immunity's Flawed Foundation, 2023. quoting an act to enforce the provisions of the 14th Amendment to the Constitution of the United States and for other purposes, 17 Stat 13, 1871. Professor Reinhardt says a government official omitted this text when he published the first compilation of federal law in 1874, unquote. If this is true, we've all been applying the wrong version of the statute. Federal judges have taken note. In Rogers versus Garrett, Judge Willett described this line of attack as a game-changing argument in this text-centric judicial era, when jurists professed unswerving fidelity to the words Congress chose, unquote. 63 F 4th 971 980 in the 5th Circuit of 2023. Willett J. concurring, if Professor Reinhardt is correct, he added, it would supercharge the critique that modern immunity jurisprudence is not just atextual, but countertextual. That is, the doctrine does not merely complement the text, it brazenly contradicts it. No decisive judgment has been returned on this line of inquiry. Hopefully, the academic community will continue to investigate. As we wait, it remains true that qualified immunity is the law of the land and commands respect under stare decisis. If the Supreme Court follows its most recent jurisprudence on that subject, though qualified immunity might be with us for but a short time, the next section explains why. The Dobbs Dilemma. In 2022, the Supreme Court upended 50 years of precedent and eliminated the constitutional right to pre-viability abortion. Dobbs, 597 U.S. at 215. Its reasoning in that case supports upending existing law here. Opponents of qualified immunity advance many of the same kinds of arguments that opponents of abortion used. In both instances, the primary complaint was that the Supreme Court had disregarded authoritative text and used raw judicial power to balance implied rights and interests. See Pearson 386 U.S. at 555. Opponents complained that the High Court short-circuited the democratic process and necessarily declared a winning side in a long-running social controversy. Dobbs 597 at 269. The arguments against qualified immunity are stronger than arguments petitioners presented in Dobbs. The people themselves already expressed the standards they expect of law enforcement when they ratified the Fourteenth Amendment and passed the Ku Klux Klan Act into law. The very enumeration of the constitutional right takes out of hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon, unquote. District of Columbia versus Heller in 2008. So it should be an easier leap of logic and lesser expenditure of political capital to conclude that qualified immunity was egregiously wrong on the day it was decided, unquote. Dobbs 597 U.S. at 268. So one might argue that law enforcement officers are entitled to keep qualified immunity because they have planned their livelihoods around its existence. Caroline Goggin, New Hampshire Police Department under fire for listing qualified immunity as job perk and recruitment process, WHDH.com, August 2021. Judges and lawyers call this a reliance interest. One judge has argued that because revisiting qualified immunity, quote, would have significant consequences for state and local governments, reliance interests recommend adherence to stare decisis. McKinney versus City of Middletown, 2022. It was strange to see that argument after the Supreme Court's abortion decision, though, because Dobbs rejected precisely that kind of vague, generalized assertion about the national psyche, 597 U.S. at 288. The court instead thought voters should resolve reliance interest, not judges. After all, just like women, law enforcement police officers and their unions are not without electoral or political power and may seek to affect the legislative process by influencing public opinion, lobbying legislators, voting, and running for office. At Dobbs also reflects the Supreme Court desire to remove itself from the center of a hot-button issue and return it to the electoral process. As one justice remarked at oral argument, in that case, when the Constitution is silent on such important interest, why should this court be the arbiter rather than the Congress, the state legislatures, state Supreme Courts, the people being able to resolve this? transcript of oral arguments at 107 Dobbs versus Jackson Women's Health Organization in 2022. There is a certain appeal to this. Since the early 1970s, the Supreme Court issued more than 100 decisions referencing Roe v. Wade. Maybe that amount of controversy on issues of life and death, where passions run high, was too much for any person or institution to bear. Over that same period of time, though, the Supreme Court has issued more than 200 decisions referencing qualified immunity. Many of those cases are also about life and death. See Mullenix. Yet, it has not yet seen fit to return this contested issue to the democratic process. It is not clear why. To all this, a layperson might wonder how such a shaky doctrine can be maintained. The next section will discuss the justice's own explanations. 4. The policy justifications. The Supreme Court says qualified immunity exists to protect government officials from the expenses of litigation, the diversion of official energy from pressing public issues, and the deterrence of able citizens from acceptance of public office. Harlow versus Fitzgerald. Even such pre-trial matters of discovery are to be avoided if possible, as inquiries of this kind can be peculiarly disruptive or effective government. Unquote. Mitchell. Pause for a moment to observe how apparent these justifications are. Emergency room physicians are critical in a real life or death sense, but when they are sued for negligence, we take for granted that they will have to respond and perhaps be subjected to discovery about their actions. The economy relies on banks to preserve, grow, and allocate resources. In the event a bank engages in fraud or facilitates a Ponzi scheme, though, its victims can come to court and ask to be made whole. The same is true for just about every realm in life. The judicial process is how our democracy provides tribunals for the peaceful resolution of all manner of disputes. Chief Justice John J. Roberts, Jr., 2015, year-end report on the federal judiciary at 2. So, it is odd for the judicial process to privilege government over every other industry. It's important to keep the public sector functioning, to be sure, but we also need functional hospitals, utilities, financial institutions, and supply chains. And in all of those systems, we accept the cost and distractions of litigation as necessary consequences of a fair dispute resolution system. The Supreme Court nevertheless assumes that qualified immunity is necessary to privilege government operations over non-government operations. Yet little to no evidence supports the assumption. Professor Schwartz's research indicates that qualified immunity is not achieving its policy objectives and may, in fact, increase the costs and delays associated with constitutional litigation. Joanna C. Schwartz, How Qualified Immunity Fails in 2017. One of her more galling findings reveals that officers are trained on broad principles, not the specific factual scenarios that appellate judges then insist were necessary predicates to liability. Joanna C. Schwartz Qualified Immunity Boldest Lie in 2021. Officers could never learn the facts and holdings of the hundreds or thousands of cases that clearly established the law, and even if they learned about some of these cases, they would not reliably recall their facts and holdings while doing their jobs. Unquote. And the notion that a government employee will change their behavior out of fear of personal liability is not borne out by the evidence. Police officers are not held financially responsible for the vast majority of settlements and judgments against them. Joanna C. Schwartz, The Case Against Qualified Immunity in 2018. At the end of the day, the court's policy-based defense of qualified immunity is simply a choice to privilege government officials over all others. The justifications are less than persuasive. The criminal law parallels. Our legal system believes that no man shall be held liably responsible for conduct which he could not reasonably understand to be prescribed. Bowie versus City of Columbia in 1964. We do not incarcerate a person unless a statute gives them fair warning that a course of conduct is criminal. Rogers versus Tennessee, 532 in 2001. Qualified immunity is similar. The Supreme Court once admitted that the clearly established immunity standard is simply the adaptation of the fair warning standard to give officials and ultimately governments the same protection from civil liability and its consequences that individuals have traditionally possessed in the face of vague criminal statutes. United States versus Lanier. Unfortunately, this reasoning reveals just how confused this doctrine is. Criminal liability is supposed to be the most difficult form of accountability. That's because a criminal conviction results in loss of liberty, imprisonment, while civil liability results only in a transfer of money. Indeed, it's supposed to be harder to prove a violation of criminal law than it is to prove a civil claim. The Constitution protects you from civil conviction, unless there is a proof beyond a reasonable doubt for every fact necessary to constitute the crime. In regards to Winship, see Mulaney versus Wilbur in 1975. In contrast, a civil judgment requires proof by only a preponderance of the evidence. Given these distinctions, you can see that the Supreme Court never should have equated qualified immunity with criminal law. They are wholly different creatures, but there is something else important going on. It concerns the level of generality at which the law holds people accountable. In a criminal case, the government can convict and send you to prison even if no one had ever committed that crime in quite the same way before. The prosecutor doesn't have to prove that the unlawfulness of your conduct was beyond debate. You can lose your liberty for a new and creative kinds of criming. See Lanier, 520 U.S. at 268. The courts reject defendants' demands for advance notice of whether something is unlawful because it would not have been possible or practical for Congress to outline each of the many possible ways that a person might commit a crime. United States versus McCoy in 1976. It is easy to see why society evolves, grows, and changes. It makes sense for Congress to criminalize fraud no matter whether it's conducted via the Pony Express or Bitcoin. People are held accountable for violating a general principle: don't defraud others. Qualified immunity turns this on its head. Under the doctrine, because the clearly established law must be particularized to the facts, we argue about whether precedent placed the unlawfulness on the officer's specific factual scenario beyond debate. White versus Pauley. Time and time again, the justices reversed lower courts for failing to identify a cause where an officer acting under similar circumstances as the defendant was held to have violated the Fourteenth Amendment. Unquote. The result is a world where courts let prison officials get away with putting someone in a feces-covered cell for 6 days rather than hold them accountable for violating the general principle: do not make people sleep in other people's feces. Consistently suggests that one of these two systems must change. If we value liberty as much as we say we do, perhaps the criminal law should refuse to convict someone unless the unlawfulness of their particularized conduct had already been held to be beyond debate at the time they acted. Or, if it is qualified immunity to yield, we should define constitutional rights at a higher level of generality, recognizing that we will never be able to outline each of the many possible ways that a person might be said to violate the Constitution. McCoy, 539. But the two systems cannot coexist with any honesty. It cannot be true that in America, it is easier to take away one's liberty than hold the government accountable for violating the very constitutional guaranteeing that liberty. A more democratic vision. This judge has no say in the adjustment or abolition of qualified immunity. But having devoted several pages to critiquing the doctrine, I do feel some responsibility to spell out the principles I believe should guide any changes. We, the people, elect the president through the Electoral College every 4 years. We, the people, elect our senators every 6 and our representatives every 2. And although we, the people, don't vote on federal judges, we nevertheless exercise vast power in the judicial branch every day through jury service. Jurors are judges of the facts. They decide what happened, who's responsible, and whether there will be consequences. They decide who to believe a little bit and who not to believe at all. They weigh evidence by the preponderance standard, the clear and convincing standard, and the beyond a reasonable doubt standard. Juries decide damages awards in civil cases, from car wrecks to discrimination claims to billion-dollar intellectual property disputes. They decide guilt and innocence in criminal cases. Sometimes they even express the conscience of the community on the ultimate question of life or death. Witherspoon versus Illinois in 1968. To say that the judiciary is undemocratic, then, is not the full story. The people enshrined in the Constitution, the powers they would wield in the third branch. Article 3 provides that all crimes shall be tried by jury. The Sixth Amendment guarantees criminal defendants the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. And the Seventh Amendment declares that all common law claims exceeding $20 must be decided by a jury. The power is simply exercised on one dispute at a time, day after day, rather than on fixed election days. Judicial supremacy has too often deprived the people of their proper role in deciding constitutional torts brought under the Ku Klux Klan Act. The doctrine of qualified immunity, as currently constructed, mistakenly lets judges quibble endlessly over whether a constitutional violation was clearly established, beyond debate, or obvious. All this frustrates resolution by the people. The doctrine also errs in giving defendants unusual rights to take immediate appeals. These appeals not only deprive victims of their right to pursue evidence in the government's possession, but they allow more judges to perpetuate the tedious legal debate. It should not have taken more than 7 years for Mr. Taylor, the Texas man housed in excrement, to secure judicial permission to take discovery from prison officials, but it did. This area of law reflects a deep distrust of ordinary people. The founders of our nation considered the right of trial by jury in civil cases an important bulwark against tyranny and corruption, a safeguard too precious to be left to the whim of the sovereign, or it might be added to that of the judiciary. Park Lane Hosiery Co. versus Shore in 1979. Today, though, federal judges are increasingly willing to take ostensibly speculated or implausible claims from the jury by granting summary judgments in complex actions turning on state of mind, or in cases involving concealed wrongdoing, a trend that has far-reaching tentacles. Andrew S. Polis, The Death of Interference in 2014. This simply need not be. This court has seated juries for quite a few years now. They pay close attention to the facts. Wanting to follow the law, they ask questions about the substantive legal instructions they receive. Their deliberations take time, which can be agonizing, but we wait because it is the fairest way to settle our disputes. And regardless of whether a judge agrees with the verdict, in our democracy, it is the jury's decision to make. In the same way we trust the collective judgment of voters in elections, we must trust the judgment of our jurors in deciding cases. Law enforcement cases are no different. I have seated juries that have found for and against law enforcement officers. The jurors know the difference between those acting properly and those violating others' rights. Their work confirms that when it comes to fact-finding, anything a judge can do, a jury can do better. Marchand versus John Miller Farms in 2018. It takes a special type of arrogance simply to conclude that American jurors cannot. In Ku Klux Klan Act cases and elsewhere, all we need to do is tell the jurors the truth. We should tell the jurors that law enforcement officers must sometimes make split-second decisions and judgments in circumstances that are tense, uncertain, and rapidly evolving. Graham versus Connor, 1989. We all know that. We should also tell jurors that officials who engage in a pattern of misconduct or act in a calculated fashion despite months of consult legal counsel are entitled to less deference. Villarreal versus City of Laredo, 2024. It's just common sense. We should instruct jurors that federal law gives people the right to be free from unconstitutional action under color of state law, whether that action be executive, legislative, or judicial. Mitchum 407 U.S. at 242. At the same time, we should instruct them that unnecessary suits against public officers run the risk of diverting energy from pressing public issues and deterring able citizens from acceptance of public office. Harlow. These principles are in tension. It is true. The Constitution is full of those tensions. Its author in one breath declared all men to be created equal, and in the other calculated a slave to be worth 3/5 of a white person. Contradiction is in America's DNA. The judiciary should permit the people to resolve these tensions and contradictions case by case as the evidence dictates. Only with that democratic participation will we reinforce a fundamental belief that we are all created equal and assure citizens that in our society, even the powerful and wealthy are subject to the scrutiny of average citizens. Honorable Kathleen M. O'Malley, Trial by Jury, Why It Works and Why It Matters, 2019. Conclusion. Desmond Green has suffered two injustices. The judiciary should not impose a third. If qualified immunity would do that, closing the courthouse doors to his claims, then the doctrine should come to its overdue end. The motion to dismiss is denied. This case is stayed so that the Detective Thomas can exercise her right to an immediate interlocutory appeal. If she declines to timely appeal, the case will proceed into discovery as to this defendant. I hope you understand the importance of this document. I hope you understand the importance of this document. Our nation is changing, and we are going to be this light that you see on the screen now that changes it all. We are going to be the light that teaches our people how to bring upon civil cases. We, the people, are going to be the bridge that ends the gap. I am you, and we are us, all a part of the great I Am.